When an agent in North Carolina has a property listed and refuses to mark it under contract once the contract is accepted until due diligence is received is naughty, naughty, naughty. Check this video out and I'll tell you why. How many North Carolina agents out there have either said or heard that until the due diligence fee is received, there is not a valid contract in a real estate transaction? We'll take it a step further. The listing agent refuses to put the home under contract on MLS without a due diligence fee in hand. Guys, I'm going to talk to you very briefly today about why this is wrong. If you're doing it or an agent is doing it to you, push back. We have to self-police and hold each other accountable. So I'm going to take it back to pre-licensing school here. And I did pull everything up. So if you see me look, it's because I'm going to read verbatim from the forms. Don't take it from me. Look at the forms that you use every single day that you should know inside out. Okay, so let's take it back to pre-licensing very quickly. Essential elements of a contract: mutual assent, so offer and acceptance, consideration, the bargain for exchange, legal contractual capacity of the parties, lawful objective and means of accomplishing the objective, and in writing for certain types of contracts only, right? So with the offer to purchase and contract, we know North Carolina requires that be in writing for it to be binding. Okay, we've got the essential elements. So what we hear from agents is that it's not a valid contract because the essential elements haven't been met because due diligence has not been delivered. Wrong, wrong. If you're an agent saying that, you're wrong. If you're an agent hearing that, tell that agent that they're wrong. Let me tell you a few reasons why very quickly. So guys, your number one weapon is knowing your contracts and what they say. And so very quickly on page 2 of the North Carolina offer to purchase and contract, it specifically states the following: should buyer fail to deliver either the due diligence fee or any initial earnest money deposit by their due date, or should any check or other funds paid by a buyer be dishonored for any reason by the institution upon which the payment is drawn, buyer shall have 1 banking day after written notice to deliver cash, official bank check, wire transfer, or electronic transfer to the paid. In the event the buyer does not timely deliver the required funds, seller shall have the right to terminate this contract upon written notice to the buyer, and seller shall be entitled to recover the due diligence fee together with all earnest money deposit paid or to be paid in the future. I'm going to stop it right there. Why is this important? Okay? It is telling you exactly what the due diligence is, how it should be delivered, and what happens if it's not delivered. Okay, this is important for 2 reasons when we're talking about this. The number one reason this is important is because it's very, very clear here that the due diligence is not a consideration. It's not the consideration that forms the contract. The due diligence is a contractual obligation, so it's an obligation of the contract, and if it is not delivered, the contract doesn't automatically become void. It becomes voidable, back to pre-licensing classes, right? And there is a very specific remedy for the situation. Okay, let's go to contracts and closing, post-licensing, right? In post-licensing, it specifically says in black and white, guys, and I'm going to put these screenshots at the end so you guys can read for yourself, Google, do whatever you need to do. But it specifically says, consideration: anything that is bargained for and given in exchange for a promise, usually the sales price or rent in real estate. So in a North Carolina offer to purchase and contract, the consideration is the purchase price, not the due diligence, not the earnest money. It says specifically, black and white, post-licensing, okay? The sales price is the consideration in a sales contract, not the earnest money deposit or the due diligence fee. It is in black and white. Now, I completely understand that newer agents out there may have not gone to the post-licensing for contracts and closings, and they may not get that. But that's why you have a broker in charge. They are supposed to be supervising you. And if your broker in charge is telling you you don't have a contract until due diligence is received, boy, I feel bad for you. They need to go back to school. They need to take that post-licensing class. That is the wrong information. So there you go, guys. Due diligence does not have to be received in order to have a valid contract. That's not the consideration. It's the purchase price. So agents, when you get a contract and it's executed by all parties, and even before you receive the signed contract, right? If the agent tells you it's been accepted and it's signed, that's acceptance. You've communicated that. So you have a valid contract. You need to put that house under contract on MLS as soon as possible, time being of the essence. Cut out because of a phone call. So time being of the essence. You don't get to say, I'm not putting it under contract on MLS until I get the due diligence fee. No, you are being willfully misrepresentative when you do that. You are representing that house is still available. So you have to put it under contract. What I will say about this too, let's say you are the listing agent and the due diligence has not been received, right? You have remedies. And I want to make sure that you know exactly what you have to do. If that due diligence fee has not been received, you, per the contract, have to demand in writing, not via text message, not email, okay? And I'm going to tell you how to do this the right way. You have to demand in writing that those funds are given within 1 banking day, okay? How do you do that? You have a notice to buyer to deliver cash, official bank check, wire transfer, or electronic transfer. That is a North Carolina Association of Realtors approved freaking document. It's there for you. So what does it look like? It'll have the seller's name, the buyer's name, and it'll have the amounts all listed there, and then the seller will sign it. Then you deliver that to the buyer's agent. At that point, when you've delivered that to the buyer's agent, the clock starts. They can't give you cash. They can't give you a personal check at that point. It's got to be certified funds, like actual funds that you know are going to be good. And then within that time frame, let's say that they do not deliver the funds within 1 banking day, okay? Your seller is then entitled to recover due diligence and earnest money. And it also says the seller may be entitled to recover reasonable attorney fees and court costs. So you guys need to be explaining this to your buyers, the importance of having due diligence and giving it in a timely manner, because this wouldn't be an issue if buyer's agents were telling their clients the implications of not doing that. And the listing agents need to know the proper way to make sure that their sellers are protected. So in this instance, it's all spelled out for us on page 2 of the offer to purchase and contract. Know your contracts, people. Know what forms are required. Also, remember about text messaging, right? If anything ever goes to court and you're texting with the other agent and things are being agreed upon, in court, that's not going to hold up. Even if you're that person's representative, there's no way to know that that's what your clients agreed to. So this is my TED Talk for today. I saw it when I woke up this morning. I was like, no. We're going to educate today to make sure that everybody knows. So stop holding off putting houses under contract on MLS that have an executed, accepted offer because you want due diligence. Buyers, agents, get your due diligence to the sellers as quickly as possible. I understand that you cannot make your buyers do something, but at least explain to them the implications of not doing it in a timely manner. And guys, let's be better. Broker in charges, make sure your agents know this. An agent should not be writing a contract at all unless they know this. That's my information for today. Like, follow me, share, check out the screenshots of all this stuff. You can find all of this on the North Carolina Real Estate Commission website and within our documents itself. If you have any questions, let me know. If you want to argue with me, let's go toe to toe. Only if you go live though, because I don't do the petty back and forth typing. I don't have time for that. We can debate 30 minutes and call it a day. Know your contracts, guys.